hearing of the Committee on the Judiciary, Subcommittee on Commercial and Administrative Law will now come to order. I will recognize myself first for a short statement. A recently released report on e-commerce revealed that online sales on Cyber Monday 2007, the Monday following the Thanksgiving weekend, were $733 million, a 21% increase from the same shopping day last year. And the total online sales for this holiday season are projected to be $29.5 billion, an increase of $5 billion from the same shopping period last year. These numbers reflect the growing number of consumers who see the benefits of shopping online. No waiting in lines, no traffic to deal with, no parking hassles, and the convenience of items being shipped to your front door. But there is an additional benefit that some consumers enjoy when purchasing items online: not having to pay sales taxes. Some companies actually post this on their websites to increase sales. States currently have limited legal authority to require remote sellers to collect sales taxes on items they sell. Instead, the burden is on consumers to remit use taxes, which are the equivalent of sales taxes to their state of residence. However, most consumers do not, partly due to the complexity in calculating how much taxes they need to pay, partly because they are not even aware of their obligation, and partly because, let's face it, those who do know about the obligation are actually going to go out of their way to avoid paying additional taxes for their purchases. State and local governments have voiced their concerns that the increasing online sales and the resulting loss in collection of sales taxes are affecting an ever larger portion of their revenues. On the other hand, online businesses remind us that the Supreme Court has ruled that states cannot require them to collect sales taxes and remit them to the states because the tax systems are overly complex. In an effort to remedy this issue, Congressman Delahunt has introduced H.R. 3396. H.R. 3396 would give Congress's consent to the Streamlined Sales and Use Tax Agreement, which several states have entered into to simplify their sales tax systems and respond to the Supreme Court's ruling. The legislation also sets forth 19 minimum simplification requirements, which the states must follow to receive authorization to require remote sellers to collect sales taxes on items they sell. Today's hearing serves three purposes. First, the witnesses will help us understand whether there is a need for a simplified sales and use tax system. Second, this hearing will provide us with an opportunity to hear about the progress that states have made in coming to an agreement to simplify their sales and use tax systems. And finally, the testimony will help us determine how soon the states can meet the requirements established in H.R. 3396 and whether the legislation fully addresses the concerns of consumers, states, and businesses. We have four witnesses with us this morning to testify about the issues addressed by H.R. 3396 and to answer our questions about the legislation and the agreement and what impact H.R. 3396 would have on consumers, businesses, and state and local revenues. Accordingly, I look forward to today's hearing. I now recognize my colleague and distinguished ranking member, Mr. Cannon, and the co-author of the bill that we are examining today for his opening remarks.
Thank you, Madam Chair. I'm pleased that we're holding this hearing after the passage of the Internet Tax Freedom Act amendments of 2007. In years past, these issues have become intertwined, and I appreciate the leadership of Chairman Conyers and Chairwoman Sanchez in keeping them separate during the consideration of the Internet Tax Moratorium. The Streamlined Sales Tax and Use Agreement, which is now expanded, I'm trying to figure out whether we should call it the SST, which seems simpler and more innocuous, or the SSUTA, which is a little more cumbersome. I think it deserves the cumbersome title, but I may lapse into the SST. This agreement was born out of a desire to simplify and reduce the administrative burden of imposing sales taxes for businesses. It was also designed to provide a framework for the remote collection of sales taxes, and this was done to address two decisions by the U.S. Supreme Court that held that states cannot compel out-of-state vendors, that is, businesses that do not have a physical nexus with the state, to collect and remit the sales tax owed by that state's residents. With the growth of Internet commerce, there is concern on behalf of many states that their sales tax revenues will decline as more consumers buy goods from retailers that the states cannot compel to collect sales taxes. A 2000 study conducted by two University of Tennessee professors showed that by 2006, the total sales tax that would be lost to states due to e-commerce would be about $45 billion. I thought that laughable years ago when we first reviewed that study, and those authors have revised their study repeatedly, and the latest estimate is that states and local governments will lose in uncollected sales taxes between $21.5 billion and $33 billion, or $33.6 billion in 2008. However, these numbers are not beyond dispute. The Direct Marketers Association estimates that in 2006, states lost only $4.2 billion, less than 10% of what the Tennessee study estimated. Further, as more e-commerce is transacted on the websites of more traditional brick and mortar stores, the so-called, I call them the click and brick stores, the number of sales that are conducted tax-free continues to decline. That is because the click and mortar or click and brick stores have a physical presence in many taxing jurisdictions and accordingly collect taxes in those jurisdictions, even for sales on the internet. In fact, Forbes.com recently reported that one of the authors of the original University of Tennessee study estimates that 50% of all sales taxes, or all sales conducted on the internet, are subject to sales taxes. So while I appreciate the concerns of the states involved in this process, it appears to me that many of the original reasons for implementing a streamlined sales agreement have not materialized and in fact are being gradually abated by the presence of the so-called click and brick enterprises. Further, while I laud the goals of a streamlined tax, it seems to me that the SST or the SSUTA, as it has been implemented, is not streamlined at all. The agreement as it exists today is over 130 pages and has been modified no less than 10 times in its 5-year history. If Congress enacts H.R. 3396, I fear that we'll be giving our imprimatur to something that is just a work in progress. Which brings me to my final point. If Congress enacts H.R. 3396, it would require businesses in all 50 states, including the 5 states that have no sales tax, to collect and remit sales and use taxes for the 17 states that actually have implemented the SSUTA. This is different from the approach that Congress usually takes when it approves interstate compacts, that is, permitting the states in a compact to share resources. Rather, H.R. 3396 would require businesses in states that are not parties to the SSUTA to, in effect, participate against their will. Madam Chair, while I commend you for holding a hearing on this legislation, I would much prefer that we take up other issues affecting interstate commerce and discriminatory taxes. To that end, may I suggest that the subcommittee hold hearings on bills that prevent states from imposing discriminatory taxes on pipelines, rental cars, and multi-channel video services? I hope the subcommittee will deal with these issues next session in the interest of putting more money into the pockets of consumers and less in the coffers of tax collectors. And may I just say, as a final note, that it's been a great pleasure to work with Mr. Delahunt on this issue over a very long period of time. He's expert in these issues, and our disagreements tend to be relatively minor and pleasant, and I appreciate that, Madam Chair, and yield back.
I thank the gentleman for his statement. I want to apologize. I misspoke earlier when I introduced you. I said that you were a co-author of the bill, and I understand that you are not. So my apologies.
But a dear friend with the author.
My apologies. So noted that you are a dear friend of Mr. Delahunt. I'm sure he's not offended.
Not in the least, Madam Chair.
At this time, I would like to recognize, for an opening statement, Mr. Conyers, a distinguished member of our subcommittee and the chairman of the full committee on the judiciary. Mr. Conyers.
Thank you, Chairwoman Sanchez, and good morning to all of you. I commend you, Madam Chairman, for holding hearings on the important legislation, and I was just busily lining out my commendations to Chris Cannon before I found out he was not a sponsor of the bill, but he's still a good friend. I joined Bill Delahunt and the gentleman from Alabama, Mr. Backus, and others, Ray LaHood, in looking at this very important question. And I think that holding hearings about a simplified, streamlined tax agreement could increase our nation's economic efficiency, facilitate the growth of electronic commerce, and help our states and local government maintain financial support for public health, and education, and safety. And so I come here with the encouragement of my governor, Jennifer Granholm, who's lost somewhere between $700 million and $1.1 billion in foregone sales tax because of the complex system that we're here to examine how we can simplify. And so I'm very happy to join you, and I would ask that my statement be included in the record.
Without objection, so ordered. I want to thank Mr. Conyers for his comments, and I would like to recognize a good colleague of mine from the state of California, Zoe Lofgren, for an opening statement.
Thank you, Madam Chair, and I would ask unanimous consent that my full statement be made a part of the record.
Without objection, so ordered.
I would just note that I think this is an important hearing. I thank you and also especially Mr. Delahunt for his years of work on this issue. I'm going to have to leave the hearing before it's concluded because I am chairing a hearing in another subcommittee. But I do believe that the goal of simplification is a worthy one. However, as we all know, it's very complicated. And with the over 7,500 distinct taxing jurisdictions in the United States with their own rates, exclusions, tax holidays, compliance could be tough. And I note that the state of California has indicated to me that conforming would require a major overhaul of California's sales and use tax system. California is not on board on this proposal yet, and as you know, I chair the California Democratic delegation. So we are concerned that we're maybe not there yet, but that the goal is a worthy one, and so we have many questions, and I'm sure we will have ample opportunity to review these issues, and I appreciate once again Mr. Delahunt's leadership and your own.
Thank you, Ms. Lofgren. Now, last but certainly not least, I would like to recognize the author of this bill for his opening statement, the distinguished gentleman from Massachusetts, Mr. Delahunt.
Well, thank you, Madam Chair, and I appreciate the opportunity and your sincere efforts to see that Congress gives full consideration to the issue of taxation of remote sales. I want to thank you for scheduling this hearing and look forward to working with you and other members of the subcommittee to make it a productive exercise. I also want to thank the chair of the full committee for his leadership on this issue, because I know it's of importance to him, and for a moment I was pleased to hear that my good friend from Utah had an epiphany, however brief. But I'm sure that after listening to the testimony today, he will give more consideration, more thoughtful consideration to the issues. Every year, the first days of the holiday shopping season are examined as an indicator of economic health. I can't say that I'm one of those people in line at the stores, at retail stores at 5 a.m. After Thanksgiving, but so-called Black Friday has become a staple of measurement in the retail sector. In the last few years, the media coverage of those early shopping days has included a new term, Cyber Monday. When shoppers who didn't get enough of Black Friday flood online stores in search of gifts for friends and loved ones. Well, this year, Cyber Monday, which was November 26, online sales increased 21% over last year. 21%. 733 million, which was a excess of 733 million over the $610 million figure in 2006. Each of the next 3 days also surpassed 700 million in sales, resulting in more than $4 billion in online spending during the week. More than $13.4 billion have been spent online during this year's holiday season to date, marking an 18% gain versus the corresponding days of last year. Now, people will use these numbers to debate the health of the economy, but my point is simple. It is that with every passing year, the American people are fulfilling more of their retail needs online as opposed to so-called brick and mortar stores. Why is this important? For several reasons. States have relied on sales and use taxes since 1932 for roughly 1/3 of their revenue. Today, our states are collectively losing tens of billions of dollars each year because the taxable transactions on which they rely are increasingly taking place over the internet. Adjusted retail e-commerce sales for the third quarter of 2007 were an estimated $35 billion, an increase of 3.6 from the second quarter of 2007, and an increase of almost 20% from the third quarter, the corresponding quarter of 2006. Almost 20%. These increases far exceed overall brick and mortar retail growth. When the remote sellers in these e-commerce transactions do not collect sales taxes, the obvious result is an erosion of the sales tax base of those states that rely on this revenue source. This amounted to state and local governments losing between $17 to $20 billion in uncollected sales and use taxes for remote transactions in the year 2004. That number is likely to go up to $66 billion by 2011, with the total loss in the aggregate coming to nearly $500 billion by that date. Put these numbers together with recent reports about the health of state budgets, and folks, we have a serious problem. 16 states are facing major budget shortfalls right now, due largely to the rising health care costs and housing costs. Fiscal year 2007, state budget balances are below 2006 fiscal year levels, and the downward trend is expected to carry over into fiscal year 2008, given the state of our economy. Many of our state and local government officials are facing a stark choice between unpopular tax increases. Many will have to resort to the most regressive of all taxes, the property tax, and drastic cuts in services, or maybe both. But this issue isn't just simply about the devastating loss of revenue. It's about fairness and equity. By failing to ensure sales tax parity between remote sellers and Main Street merchants, we are putting at risk the thousands of small businesses that sustain our local economy, as well as the fabric of our communities and our neighborhoods. For example, it's that small store, the independent bookstore, for example, that doesn't just provide books, it sponsors the Little League team, it creates a venue for people to come together, it enhances, if you will, a sense of community. If there is any bill that is supportive of the small business owner in this country, it's this legislation that's before us today. And please note, it's both local and remote businesses that benefit from local infrastructure, roads, fire, and safety services in our cities and towns. But right now, most remote sellers have an unfair advantage over our their brick and mortar competitors. States Cities and towns must be empowered to level the playing field for their hometown businesses. And I'm not in any way opposed to the progress represented by e-commerce. I'm amazed by it. But I strongly believe that fairness requires that remote sellers collect and pay the same taxes that our hometown businesses on Main Street have to collect and pay. You know, the states have gone to work. They've done their job. And it's time that Congress recognizes that. The states went to work beginning with the creation of the Streamlined Sales and Use Tax Agreement, which has served as a blueprint for states to streamline their taxation systems. In the 108th Congress, I stated back then that the states have made substantial progress and that once a sufficient number of states have implemented the agreement, Congress should move expeditiously to pass what was an earlier version of the bill that we're having this hearing on today. That bill, like the one before us, would simply bless, if you will, the agreement and authorize those member states to compel out-of-state sellers to collect and remit sales and use tax arising from sales out of the member's jurisdiction. Our current bill also outlines minimum simplification requirements and exempts remote small businesses from any such requirements. Let me repeat, it's straightforward, it's narrowly tailored, and responds directly to the Supreme Court's conclusion in Quill. It is Congress's authority and responsibility to enable the states to develop tax policy that reflects today's economy rather than buying them to antiquated notions of what the marketplace was. But yet we have yet to adopt what I believe to be common sense legislation. Well, since October 1st of 2005, approximately 1,100 remote retailers have volunteered to collect an out-of-state sales tax for these states. To date, member states have collected almost $115 million in new sales tax revenues from those volunteer sellers, which previously would have been uncollected. You know, in the 7 years since this bill was first introduced, the states have organized and lined up to address the issue. They've done everything that we've asked them to do. Now that the states are meeting their responsibilities, it's long due past that the federal government and that the United States Congress stand up and do what is clearly our responsibility. Recognizing that the ranking member is from Utah, I thought it might be apropos that I conclude with a very brief quote from the former governor of Utah, the current Secretary of Health and Human Services. A good man, a man with great common sense, and on this particular issue, a man of great insight and intellect. These are Secretary Leavitt's words back in 1995, and I presume, I have no doubt that he continues to embrace them. The current sales tax is a great system of taxation for the agricultural and industrial economy it was created for, but it's unworkable now. There is no new tax involved in a streamlined sales tax system, none. Every tax obligation talked about exists today. Citizens know what the sales tax is and what it pays for. The schools their children attend, the roads they drive, and the fire and police departments that protect them. The new streamlined sales tax system, when fully deployed, treats every buyer and seller the same. No special privilege, no selective burden, just a level playing field. The new system is voluntary. Whether you're a New Hampshire that has no sales tax or a Nevada where sales tax comprises 80% of all state revenue, it's your choice. If you don't like it or you don't need it, don't use it. I yield back, and I
Would the gentleman yield briefly?
very briefly.
I noticed the clock wasn't working as you spoke briefly.
I want it noted for the record, the chair has been very generous with the
I
time.
would note that, and I
My dear
express
friend,
gratitude.
Mr. Levitt, former Governor Levitt, now Secretary Levitt, made that statement in 1995, generations ago in internet time. And I think that the state legislature, which is now back, the Utah State Legislature, which was, I think, the first legislature to back the SST, has now pulled out and is in that standby status. And I think wisely so, because time has led them to understand the difficulties of the SST and the burdens that it puts on the world probably don't make sense, and that's why we're going to have this hearing. So we'll examine that a little more, but want to validate the prescience of my former governor, but the transformation of society that has made him less relevant. Thank you. I yield back.
Well, I'm glad everybody's happy about today's hearing. I hope that it will provide us with the information that we're seeking in order to make a more informed decision on where we fall on this issue. I want to thank Mr. Delahunt for his opening statement, and without objection, other members' opening statements will be included for the record. Without objection, the chair will be authorized to declare a recess of the hearing at any point. And at this time, I'm pleased to introduce the witnesses for today's hearing. Our first witness is Joan Wagnon. Ms. Wagnon is currently serving as Secretary of Revenue for the state of Kansas and was appointed to her post on January 13, 2003 by Governor Kathleen Sebelius. Is that correct pronunciation? Prior to her appointment, she was president of Central National Bank, Topeka. Elected mayor of Topeka on April 1st, 1997, Ms. Wagnon was the first woman to serve as mayor since the city's incorporation in 1857. Wow, what a breakthrough. She also served 12 years in the Kansas House of Representatives from 1983 to 1994. Ms. Wagnon currently serves as president of the Streamlined Sales Tax Governing Board and has been an officer since the organization's inception in 2005. She also has served as chair of the Multi-State Tax Commission from 2005 to 2007 and is currently on the board of directors for the Federation of Tax Administrators. Our second witness is Wayne Zakreski. Mr. Zakreski is the Vice President and Associate General Counsel for Tax for JCPenney Company Incorporated, where he has responsibility for all legal matters related to tax, audit of sales, use and state income taxes, property tax compliance and value appeals, and state tax research and planning. From 1981 to 1988, he served as Attorney Deputy Chief Counsel of the Arkansas Revenue Division. He has been an active participant in the Streamlined Sales Tax project since its beginning and currently serves as a member of the Board of Directors of the Business Advisory Council to the Governing Board of Streamlined Sales Tax Agreement. He also served as co-chair of the Steering Committee for the Joint Cost of Collection Study, which was a joint business and state government project to provide data concerning the costs of the current sales tax system to business and to provide tools to compare that cost with these costs of a streamlined system. I want to welcome you to our panel. Our third witness is George Isaacson. Mr. Isaacson is a senior partner in the law firm of Brand and Isaacson in Lewiston, Maine, which represents over 70 direct marketers and electronic merchants throughout the United States in connection with state sales, use, and income tax matters. For over 15 years, he has provided counsel to the Direct Marketing Association and has represented the DMA in the filing of amicus curiae briefs in state and federal courts. In addition to tax advice, Mr. Isaacson also consults for direct marketers on a wide range of electronic commerce issues. I want to welcome you as well. Mr. Isaacson also serves as outside general counsel to LL Bean Incorporated and frequently speaks before business groups and trade associations regarding legal issues affecting electronic commerce. Our final witness is Steve Rauschenberger. Mr. Rauschenberger is president of Rauschenberger Partners, a partnership with extensive experience in government affairs, strategic development, and business management. Prior to founding the firm, Mr. Rauschenberger served for 15 years in the Illinois State Senate, holding various leadership positions, including Assistant Republican Leader and Chairman of the Senate Appropriations Committee. He is immediate past president of the National Conference of State Legislators, NCSL, where he also served as co-chair of the Task Force on Telecommunications and electronic commerce. Prior to his tenure in government, Mr. Rauschenberger was president of Ackman Brothers Incorporated, which owned and operated 3 retail furniture stores. And before taking that position, he was a partner in the Rauschenberger Furniture Company, a third-generation family furniture retail business. We want to welcome you to our panel this morning. I want to thank you all for your willingness to participate in today's hearing. Without objection, your written statements will be placed in the record in their entirety, and we would ask that you please limit your oral remarks to 5 minutes. We have a lighting system when we remember to employ it, which gives you a green light at the beginning of your testimony. When you are 4 minutes into your testimony, it will turn yellow to warn you that you have a minute remaining. And when the yellow light turns red, you know that your time has expired. If we catch you mid-sentence when the light turns red, we would ask that you please just summarize your final thoughts so that we can move on to the next witness. After each witness has presented his or her testimony, subcommittee members will be permitted to ask questions subject to the 5-minute limit. With that, I would now invite Ms. Wagner to please proceed with her testimony.
Well, good morning, Chairwoman Sanchez and Chairman Conyers and Ranking Member Cannon and all of the rest of you members of the committee. I do appreciate the opportunity to speak to you today. I am here representing the governing board of the Streamlined Sales Tax, and I do refer to it as SST because it's shorter. And I want to encourage Congress to recognize that the simplifications that we have achieved in our member state sales taxes are sufficient to remove the burden on interstate commerce that the Supreme Court noted in Quill v. North Dakota, and sufficiently simplified for Congress to allow the states to require remote retailers to collect our sales tax. That is our goal. That is our work on simplification, and that leads to mandatory collection. I wanted to make one point today about the nature of...
Wagner, I'm sorry, can I interrupt you for a moment?
Yeah.
We just want to check and make sure that your microphone is on, otherwise your testimony isn't recorded.
It says that it's green.
Okay.
Am I not close enough?
I suspected as much. I just wanted to verify, and I apologize for interrupting.
Not a problem. I'm just still looking to see my light, so...
We'll give you additional time at the end to make sure that you finish your statement.
My first point was that the nature of retail is changing, and I think Congressman Delahunt's statement and Ms. Sanchez's statement have eloquently spoken to that, and I won't go into it again, except to say that our sales tax bases in states across this country are rising maybe at 2% a year. And we see the erosion at maybe 27 to 30% a year. So that point is so valid. So let me really give you an update on where we are with SST, about our need for simplification. And I am quite frankly amazed at the phenomenon that is the streamlined sales tax, because you, for the first time, have seen business stakeholders coming together with tax administrators, legislators, and members of the public to devise solutions to problems that have been huge. We have a myriad of sales tax laws. You asked, why do we need to simplify? Just the number of forms that you fill out in order to report in every state, they're all different. We now have 22 states that are part of the agreement, and they all have a single reporting form done electronically. That in and of itself is simplification. There's a map in your packet that we've provided that shows you the number of states. Today we have 22. It is my hope that we have 10 more states that we are working with, that over the course of the next year, if we are able to maintain the progress that we have made so far, we'll be able to join with us. 28% of the states of the country's population now lives in a streamlined state. The reason those states are not, those 10 are not with us now, we need to make a minor adjustment in our sourcing rules so that some of the barriers that currently exist can be overcome. We have a meeting scheduled in Dallas next week, and we'll be discussing those changes. We made a number of changes in the agreement, as was noted in the opening remarks, because we had not completely finished the work when the agreement was first adopted. But what we have done so far is absolutely amazing. Since December of 2005, we have been able to bring those 22 states on board, achieve the simplifications that are outlined in the bill. And Section 6 of that bill is a wonderful framework for what simplification looks like. And our annual report does show that just in the last year, we brought in almost $89 million for the 2007 fiscal year. So if you compare that to the number that's collected overall, it's been an explosion of collections by these 1,072 sellers that are currently registered. What does our simplification look like? We have certified service providers that provide services free of charge to remote sellers to collect and distribute these new taxes. So what could be simpler than that? The payments come from the new money that's being collected. We do have a simplified reporting form used by all states. In the past, it was said there wasn't sufficient software, but that's just not right. Software's been there. What's been missing is the rates and boundaries databases where states will certify these are the rates in all of these different jurisdictions. These are the boundaries. We do not allow them to change more than once a quarter. We give notice to retailers when it does change. We hold them harmless if we use these states' round boundaries and databases. And so that makes it possible to do the collection. We have a central registration system that provided amnesty in the first 12 months, and it provides liability protection for people that are enrolling. We have managed to, I believe, accomplish everything that is in Section 6 of the bill, where there is a listing of the simplification measures, with one exception. We have not gotten around to the issues in the dispute resolution process. We've been pretty busy organizing the board. We've taken care of our governance issues. We've come up with the standard uniform product definitions. The most recent amendment to the agreement was an amendment about digital goods. We had a hard time figuring out what digital goods are going to look like in the future, but we finally have come up with those descriptions. I think you're going to see fewer amendments in the future, more effort towards bringing in new states. I think you're going to see more effort to work with you in Congress to help you with having information that shows that we have indeed simplified the system and that our voluntary system is bringing in to the best of our ability. But the question is, should it stay voluntary forever? I don't think so. I think we're letting a lot of people off the hook who are operating, as Chairman, or as Mr. Delahunt said, at a competitive advantage over the people in your home states because they don't have to collect the sales tax, and that simply isn't fair. So we would ask you to overturn the Quill decision, to work with us and give us the ability to collect this tax.
Thank you, Ms. Wagner. Your time has expired, and I'm told that the lights are actually not working.
They're not working. I had no idea where I was.
We're employing them. They just aren't working. So we're resorting to good old-fashioned ingenuity. Roberta will let you know when you have 3 minutes remaining and when you have 1 minute remaining. We do have the timer up here, so thank you for bearing with us. Hey, we just roll with the punches. What can I say? I want to thank you for your testimony, and I want to invite Mr. Zakreski to please proceed with his testimony.
Is that
Yeah, that's it. Just move the microphone closer.
a little closer? Thank you, Chairwoman Sanchez, Chairman Conyers, Ranking Member Cannon, and members of the committee. We appreciate the opportunity to talk with you this morning. I'm Wayne Zakreski. I'm Vice President, Associate General Counsel for Tax for JCPenney. I'm here to talk to you on behalf of JCPenney and our trade association, the National Retail Federation, and to speak in support of Mr. Delahunt's Bill 3396. Both on behalf of Penny and the National Retail Federation, I want to urge your support for this important piece of business legislation. As a representative of JCPenney, I've been involved with the Streamlined Sales Tax project since its beginning. I currently serve as a member of the Board of Directors of the Business Advisory Council to the Governing Board and as co-chair to the Steering Committee for the Joint Cost of Collection Study. JCPenney is a multi-state retailer. We've got $20 billion in sales, and those sales occur through both our stores, catalog, and an internet business. Our internet site is one of the top largest internet sites for selling apparel and home furnishings. And to give you a picture of how that business is growing, in 2002 we had $400 million in sales through our internet business. This year we should hit $1.4 billion. In that short period of time, that business has grown by threefold. True, some of that business is moving customers from the catalog to the internet, but this represents a remarkable growth in the internet marketplace, which has got to be paid attention to. So we're here to ask you today to level the playing field between sellers like J.C. Penney, who are required to collect tax because we have physical stores, and those people who exploit the marketplace in your states virtually rather than through physical sales, physical presence. We remit $1.2 billion in sales tax each year, and that $1.2 billion that we collect and our competitors don't give them a competitive advantage, not because they provide innovation or value to the customer, but because they are not required to collect sales tax. We believe there are compelling reasons that you should act now to allow the streamlined states to require collection. Primary among those is the simplification and uniformity that Streamlined Agreement has provided, that Chairman Wagner has just described to you. We believe, though, that we commend them for this effort, but we believe a lot more states would participate if they were rewarded for this difficult effort by having the ability to require remote sellers to collect the tax that's due from their customers. We support this bill because we believe it would strengthen the Streamlined Agreement by mandating that certain levels of uniformity and sophistication and simplification be maintained, and providing an enforcement mechanism to assure compliance. In the past, there's been a major stumbling block to y'all acting on this proposal, and that is the concern that that collection places on businesses, particularly small businesses. That burden is illustrated by the results of the cost of collection study that I chaired. That study was conducted by a group of businesses and government organizations interested in Streamlined, who wanted to measure the cost that collecting would place on business. The result of this study showed that over all businesses, the cost of collecting under the current system was 3.09% of the sales tax collected. If you break that down by business size, for large businesses with sales over $10 billion, that cost was 2.17%. For mid-sized businesses, it was 5.2%, and for small businesses, it was 13.4%. This demonstrates that there is a significant burden on all businesses, and that is significantly more for small businesses. We believe, though, that the right way to relieve that burden is not necessarily through a small business exception, but to provide for reimbursement for all businesses based on this cost of collection study. That rather than having to draw a single line between all business, if you provide for reimbursement, it is a fairer system. It also eliminates the burden generally on interstate commerce by providing for reimbursement to all sellers, and it takes care of that burden by removing it through compensation. So again, we would like to urge you to support this and think about this as an alternative.
Thank you, Mr. Zakreski. We appreciate your testimony. It came in right under the 5-minute mark. We have been summoned across the street for votes. That's the bells that you've heard. So we're going to take a recess to allow members to cross the street to vote, and hopefully in that time we will also get the engineer to look at the lighting system, and we will reconvene immediately after the last vote.